Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you for all of your support of GunGuyTV. It's Monday. Here's a Second Amendment update in 5 minutes or less, I hope. The Supreme Court is about to weigh in on Wolford v. Lopez. This case could reshape how far states can restrict your right to carry and where, especially on private property. So what is Wolford v. Lopez about? Hawaii, like California, has a law that bans carrying a firearm on private property open to the public. Restaurants, stores, hotels, you name it. You can't carry unless the property owner gives you express permission. That could be a sign in the window that says, "Firearms are allowed here." How often have you seen those? Or verbal invitation. This law is sometimes called the vampire rule. You may have heard it called that. Like a vampire, a gun owner must be invited in. The Ninth Circuit upheld this law under its private property default rule. The problem is the law completely inverts the traditional rule of carry throughout the United States' history, turning tradition upside down. Traditionally, the default rule was that citizens could legally carry on private property open to the public unless the owner expressly forbade it. So the default was freedom to carry, not a permission-based prohibition. Hawaii's law flips that presumption on its head. It creates a de facto ban unless permission is granted. The Trump administration, through the Department of Justice, filed a strong amicus brief opposing Hawaii's law. The DOJ brief stresses that Hawaii's default ban unless invited approach effectively nullifies the right to carry in most public places. Obviously, most private property owners don't post a sign that explicitly says guns are welcome here, so the law ends up banning lawful carry by default. The Trump brief also argues that the law runs afoul of the Bruin decision because the Bruin decision requires a historical precedent for firearms restrictions. Historically, there is no precedent for a default no carry unless invited type rule. That makes this law clearly unconstitutional. So then the question becomes, what will SCOTUS do? Well, they could strike down Hawaii's law entirely. I think that's fairly likely. In that case, they would rule that default bans violate the Second Amendment. The justices are well aware that legislatures and lower courts are bending over backwards, attempting to get around the Supreme Court's clear instructions in cases like Bruin and others. But, knowing the Supreme Court, there's also a chance of a narrower ruling, affirming some aspects of the law while limiting others. And as I mentioned, California has a very similar law, sensitive place zones, restrictions requiring posted signs or property owner permission for lawful carry. If SCOTUS rules against Hawaii, then these laws will be vulnerable. Parts of California's default bans, if not all of them, may need to be removed or narrowed. Other states across the country with similar default no-carry rules could face the same legal exposure. On the other hand, if SCOTUS rules for Hawaii, which I think is quite unlikely, but it's possible, anti-gun lawmakers would then have judicial cover. Legislatures could pass new bills, adding more sensitive places, parks, transit hubs, shopping centers, even large community commercial-type zones. California already has a lot of that stuff. But again, I think such a result is unlikely given the court's earlier decisions, and I hope that I'm right. Let's be clear one way or the other, the historical argument is on our side. Throughout U.S. history, law-abiding citizens had the default right to carry in public and on private property open to the public. Property owners could always say no, and they could exclude them, but the state could not impose blanket bans. Hawaii's law, and California's for that matter, break from that tradition. And the vampire rule, as it's come to be known, has no historical precedent whatsoever. It's a modern invention designed to chip away at your rights and nothing more. Okay, so that said, this thing's going to be an ongoing battle regardless of how SCOTUS rules on this particular law. So you want to continue to support the California Rifle and Pistol Association, Second Amendment Law Center, Gun Owners of California, Gun Owners of America, and the like. Those are the folks who are going to battle this in court regardless of how SCOTUS rules in this particular case. And if you would also support GunGuyTV, I'd really appreciate it. In fact, come take a class with us at Practical Defense Systems. That helps me keep the lights on. Thanks again. We'll see you next week with another update on the Second Amendment, and I will try each time to do it in under 5 minutes. Stay safe.